If you've ever applied for PIP, personal independent payment, because you have a long-term health condition, and in this video in particular, you have a mobility issue, and you've been told, no, you don't qualify for the high level of PIP because you go out and about, or you can get out and about, then this video is going to be for you. In this video, I'm going to be breaking down the rules when it comes to PIP descriptors, particularly for mobility, and I'm going to be going over a wonderful, brand new, fresh off of the press decision from an Upper Tribunal who have yet again corrected the DWP when it comes to wrongly assessing disabled people in regards to descriptors. So without further ado, let's crack on into it. Now, this is something that personally gets my goat because it's something that DWP's own barrister failed with me in an employment tribunal. So it brings me great joy to share that not only was I right and challenged their own barrister and of course the judge, but the Upper Tribunal reinforced what I was saying all along. Surprise, surprise. So before I go down the nitty gritty and explaining exactly what it was that they have been doing wrong and probably still are doing wrong, I'm going to sum it up quite simply like this before we go into it. The judge has said that DWP PIP assessors have been asking the wrong question. The wrong question when assessing disabled people for the mobility part in this specific example. I mean, the truth be known, they're probably asking a lot of wrong questions, but in this particular example, we're just going to stick to the sheer facts of this case. And by the way, because this has now been ruled, it sets a precedence for all of you lovelies who have been refused on the same or similar grounds. I'm sure that's going to bring great joy to so many of you. Now, first of all, if you don't know what the PIP descriptors are specifically, you can go along to the Justice Journals. I'm going to leave this underneath. This is a page that anybody can access. You don't have to be part of our private insider membership, although it would probably be of serious advantage if you did, particularly if you want to apply for PIP. But getting back to it, this is all of the descriptors for all of the daily activities and also the mobility activity in there as well, okay? And if you are someone that struggles with writing letters, advocacy letters, don't forget you can also use the tool that I created, Justice Writer Pro. This is something that helped me win my cases against the Department of Work and Pensions, I might add as well. It has been trained by me for 5 years. This is not your general AI, trust me on that. So once you've had a little look at those descriptors, the next thing you want to have a look at is this. And you can see the case there if you want to look it up. Now, this case specifically relates to 2 of the descriptors in the mobility part. And it is this one here, which is 1E, cannot undertake any journey because it would cause overwhelming psychological distress to the claimant. And it also relates to this: cannot follow the route of a familiar journey without another person, an assistance dog, or an orientation aid. These are the 2 main elements that I'm going to be discussing in this video. Now, what the Upper Tribunal have said, well, in fact, let's go back to what DWP have been doing. What DWP have been doing is that they have been asking E and then F, first of all, because of course, that's how it's set out on their forms. They're the authors of this. They have set them out. However, it may interest you to know that ironically, they've got them back to front. They have got E and F in the wrong place. Now, I wonder why they would do that. Well, the reason they are probably doing it is because they're saying, well, if you can't undertake a journey because it would cause such psychological distress, which is worth a 10 stonking fat points, by the way, then they're saying, well, if you can't undertake a journey, then, and this is what DWP was saying, and of course is wrong, then they're saying, then it follows, doesn't it, that you wouldn't obviously be able to follow the route of a familiar journey without another person, an assistance dog, or an orientation aid. Okay, now that is what DWP have stated. Now there are two main points here. The first one is that this here cannot undertake any journey because it would cause overwhelming psychological distress to the claimant is any unplanned journey. And I have already covered other videos, other court decisions over this. And again, in Insiders, I break things down a lot more, but obviously this is YouTube. There's only a certain time limit you guys tend to watch. If you watch my videos through to the end, I might leave them on YouTube, but you don't. So I give them over there. Now, the tribunal, the judge, have said, actually, this is wrong. The correct sequence is this. It's F before E. It's not E before F. And the reason why they say that is that E can only correctly be considered once F has been considered. So they're saying that actually DWP have been asking them in the wrong order. And by doing so, that is automatically failing lots of claimants. And I want to know if this has happened to you, okay? If this has happened to you, I want you to put it in the comments if you've been failed on these 2 points alone. And, you know, I'm just going to point out the elephant in the room here. Why do DWP always do this on descriptor points where there are a lot of points? They're not doing it on, of course, they wouldn't be getting A and B round the wrong way, or, you know, it wouldn't be a concern with that, would it? It's only on the biggies. It's only on the descriptors that carry the maximum amount of points. And we all know why that is, because that would contribute massively towards people getting the higher level of PIP. I mean, I'm just going to say it as it is, because how disgusting is that? Like, how disgusting. And if DWP are getting things like this wrong, and they have been doing so for, I don't know how many people have been affected by this, it must be thousands, how many other things are they getting wrong as well? I mean, when the High Court said that the DWP is not fit for purpose, I mean, they were not jesting, were they? They were not. Anyway, I digress. Let's get back into it. Now I'm going to come to the next big part of this 60-page summing up. I have read it in detail, and this is not going to be the only video I'm going to be doing on this, so make sure you are following and subscribe to this channel. And thank you everyone else as well for subscribing. The next part, and I know this is going to affect, I know so many people are going to get triggered by what I say next, but I'm going to say it. The tribunal has said what a PIP claimant has said they could do or couldn't do in a relevant period, so for the period that they are being questioned on for their PIP application. The tribunal have said it is relevant. Of course, it's relevant to the claim, but it is not an entire decision-making factor. It is not determinative, okay? Now, I know because I've read the comments, I get lots of emails, I have lots of people in insiders that have got, quite frankly, crippling conditions, literally crippling conditions, and they get 0 pip. And they come in insiders, and I'm like, how on earth? Now, I don't want to plug it again, guys, because I think some of you get annoyed with me for plugging it, but for the love of God, please get the health journal. Like, this is an evidence system all in itself, because I'm going to bring you on to the next part now of what the judge says about evidence, okay? Claimant evidence. And I think this is really important because I know so many people become like hermits. They start living like hermits because they are fearful of organisations like DWP. They are fearful of very nosy neighbours that have got far too much time on their hand, and they're fearful of very spiteful people. So I'm going to say this twice, and I'm going to try and say it as loud as I can. So if you get irritated by my volume, like at this point, I really don't care. If a Pip claimant says that they struggle to make journeys, unfamiliar journeys, and if they say that they generally cannot go out because they suffer from overwhelming psychological distress, but then they do go out, that the tribunal say cannot be used against them. In the sense that it is not a factor that the Department of Work and Pensions can use to end the case and go, oh, well, you said, you can't go out. You say you suffer from psychological distress, but your bank statement says, you went and bought an ice cream down by the river one day, right? That means you're just lying, aren't you? You're making it all up as you go along. Okay? Thank God for the Upper Tribunal. Right now, I just want to kiss this person's feet. That is a metaphor, by the way, like I don't want to do it literally. Now, here's where lots of people could potentially get extra points or use this to give further evidence on their lifestyle and how they live and how their disability affects them. So the decision maker has to consider for each day in the required period whether the claimant would have satisfied the descriptor if assessed on that day. Okay, so it's not, oh, we're assessing you today and you look like, you could, go out for a walk, or you look like you could drive a car. We think you're capable. They can't do that. And again, I know this is going to bring joy to so many people because the judge has said they cannot do that. This is a ruling in court now. Okay, so, and where relevant, whether they had the assistance contemplated by the descriptor. And to add, the judge also said, or the tribunal, because there were a few of them in this hearing, the tribunal also says that where someone has not gone out or has gone out less than expected, the reasons for that need to be examined as well, because that could potentially give rise to somebody being awarded even more points. I mean, it's really refreshing, isn't it, to see somebody, a decision maker in the disability arena, so to speak, legally, being like pragmatically honest, factual, and just not beating around the bush, giving us real good information. There is another relevant part in this actual hearing, and the tribunal have also said that DWP, in particular Pip assessors, cannot leave this massive gaping gap between 1E and 1F. And this is a direct quote. They say the law should not be applied so restrictively. Restricted being the key word. So restrictively that somebody scores under neither descriptor, even though their functional limitation is very serious. I'm just going to say halla flipping you right now. I've actually got goosebumps on my arm from this, because I know it's going to help so many of you, and I am flipping overjoyed to be able to sit here. I feel privileged right now to make this video and share this information to you. I'm so happy about this. If you're happy about it, smiley emoji in the comments, please. Now, because I have slayed the beast, so to speak, in court 3 times, I've sued the Department of Work and Pensions, I know how subjective evidence can be. You can have the same evidence in 2 different hands of 2 different barristers, and one could make it tell one story and one could make it tell another story. So to finish up, I'm going to be leaving you, and there are going to be many more videos about this, I can tell you. I'm going to be leaving you one of the biggest quotes from this case, which I absolutely love. And quite frankly, it's going to be the permanent sting in the arse of Pip assessors that they wished was never published in the general public domain. Are you ready for this? So we all know when we're assessed by Pip assessors how they like to isolate each little thing and whip off a mark here and whip off zeros there. Well, the tribunal say in actual fact, when assessing somebody correctly, because not all Pip assessors are awful, when assessing somebody, a disabled person, correctly, the entirety of the person's conditions should be taken into account, particularly when looking at 1F, which I'm just going to put back up on the screen again. Okay, it's this one here. Cannot follow the route of a familiar journey without another person, an assistance dog, or an orientation aid. So, as an example, if somebody has psychological distress and another condition like visual impairment or another physical or mental health condition, the overall effect of all of that needs to be considered. So, this is really, really, really important, because somebody may not technically have a mobility issue, as in they could physically move around, okay? But if they are psychologically distressed or, psychologically distressed, that distress, psychological distress, may prohibit them from moving around and being mobile, obviously. Now, clearly, Pip assessors are kind of like, cherry picking a little bit here. And the tribunal said, no, you can't do that. You have to look at the whole thing. And for somebody that suffers, actually myself, with extreme social anxiety, I can tell you that is something that is very, very real. Many people do not go out or do not, take trips and do things because of serious psychological distress, serious social anxiety. I just actually do happen to have a physical disability as well, but I hope that is helpful for lots of people. And this here has to be like the best quote. The tribunal says it would be artificial and contrary to the purpose of Pip to ignore part of the claimant's real situation. I know so many of you are going to be in the comments going, mine was ignored. Well, they jolly well ignored mine. Well, now we can raise the roof on this as well. Anyway, guys, that is all I'm going to be covering. It's a 20-minute video. Please leave a little comment behind. Share this one out as wide as you can so that people with Pip can actually, people with disabilities, can get what they're entitled to. Reapply again. Reapply, reappeal, and get what you are entitled to, because it is no fun not being able to walk. It is no fun not being able to go outside of your house because you suffer trauma or something else. God bless you all, and see you again in the next video.